Welcome to Literary and Jury Charge Practice. We'll start out with some jury charge. Ready? Here we go. Dr. Barbara Ziv was permitted to express opinions about Ms. Bovang's mental state because she possesses specialized knowledge as a result of her education, training, and work experience. In weighing Dr. Ziv's testimony, you may consider her qualifications, the stated basis for her opinions, the reasons she gave for her opinions, the reliability of the information supporting those opinions, as well as all the factors I have previously mentioned for evaluating witness testimony. You may also consider the compensation she received in connection with this case. To the extent you find her opinion, testimony credible and reliable, you may rely on it. To the extent you do not, you need only not rely on her testimony. Opinion testimony should receive whatever weight and credit, if any, you think appropriate given all the other evidence in the case. You heard evidence that certain witnesses discussed the facts of the case and their testimony with lawyers before the witness appeared in court. Although you may consider that fact when you are evaluating a witness's credibility, you should be aware that there is nothing unusual or improper about a witness meeting with lawyers before testifying. Indeed, it would be unusual for a lawyer to call a witness to testify without such preparation. You have heard evidence in the form of stipulations or agreements as to certain facts or as to testimony a person would give if called to testify. Where the parties have entered into an agreement as to certain facts, you must regard the agreed upon facts as true. Where the parties have stipulated as to what a witness would say if called to testify, you must accept the parties' agreement as to what the witness would say. I will now turn to the law applicable to the specific claims in this case. As you know, the plaintiff in this case is Hannah Bovang. The defendants are Benjamin Way, NYG Capital LLC, DBA New York Global Group, and FNL Media LLC. I will refer to NYG Capital LLC as New York Global Group. Ms. Bovang claims that Mr. Wang violated the New York State human rights law and New York City human rights law by subjecting her to unwelcome sexual advances and by using her reaction to those unwelcome sexual advances as a basis for decisions concerning her employment. Ms. Bovang claims that New York Global Group and FNL Media are liable for Mr. Way's conduct because of the positions he held at these companies. Ms. Bovang further alleges that all of the defendants violated these same statutes by retaliating against her for complaining about Mr. Way's alleged conduct. Ms. Bovang has also brought assault and battery claims against Mr. Way and a defamation claim against all defendants based on statements published in an internet publication called The Blot Magazine, which is allegedly owned by defendant FNL Media LLC. Ms. Bovang claims that Mr. Way is the publisher of The Blot Magazine and the author of the allegedly defamatory statements in it. The defendants deny all of Ms. Bovang's claims. They contend that Mr. Way did not subject Ms. Bovang to unwelcome sexual advances, and they deny retaliating against her. Defendants further contend that Ms. Bovang's employment in New York Global Group was terminated for lawful reasons. Mr. Way denies having committed assault and battery, and all defendants contend that any statements made about Ms. Bovang, including those in the Blot Magazine, were not defamatory and were not made in retaliation for any activities by Ms. Bovang that the law protects. You should be aware that you will be asked to render separate verdicts as to each defendant and as to each of Ms. Bovang's claims. Accordingly, you will be required to separately consider Ms. Bovang's claims against each defendant and what the evidence is as to each defendant and as to each claim. Keep in mind that in order to prevail, Ms. Bovang must prove each element of her claims by a preponderance of the evidence. I will now turn to the law that governs Ms. Bovang's claim for quid pro quo sexual harassment under the New York State human rights law and the New York State human rights law. New York City human rights law. The New York State and City human rights laws make it an unlawful discriminatory practice for an employer to refuse to hire, to discharge, or to discriminate in compensation or in terms, conditions, or privileges of employment because of the sex of any individual. Here, Ms. Bovang alleges that Mr. Way, New York Global Group, and FNL Media violated the state and city human rights law by engaging in what is called quid pro quo sexual harassment. To prevail on her state and city human rights law quid pro quo sexual harassment claims against Mr. Way, Ms. Bovang must establish by a preponderance of the evidence that 1. She was subjected to unwelcome sexual conduct by Mr. Way, and 2. Her reaction to that conduct was then used as a basis for concrete employment actions affecting her. I will now explain these elements in detail. Ms. Bovang must first prove by a preponderance of the evidence that Mr. Way made sexual advances to her and that those advances are unwelcome. To determine whether Mr. Way's alleged advances were unwelcome, you must consider whether or not Ms. Bovang and Mr. Way were engaged in a consensual sexual relationship. An employee's participation in a consensual sexual relationship with his or her employer does not constitute quid pro quo sexual harassment. However, if you find that Ms. Bovang and Mr. Way engaged in a consensual sexual relationship for a period of time, but that Mr. Way's sexual advances later became unwelcome, Ms. Bovang is not precluded from recovering for quid pro quo sexual harassment. Ms. Bovang must also prove that her reaction to Mr. Way's alleged unwelcome sexual advances was used as a basis for concrete employment actions that affected her. A central issue in a quid pro quo sexual harassment case is whether the employer has expressly or tacitly linked concrete job benefits to the acceptance or rejection of sexual advances. Ms. Bovang must thus show either that 1. She rejected Mr. Way's unwelcome sexual advances and suffered concrete employment-related consequences, or 2. She submitted to his unwelcome sexual advances in order to avoid concrete employment-related issues. Concrete employment actions include a significant change in employment status, such as hiring, firing, failing to promote it, reassignment with significantly different responsibilities, or a decision causing a significant change in employment benefits. Ms. Bovang must demonstrate that Mr. Way took concrete employment actions regarding her employment based on her reaction to his alleged unwelcome sexual advances. Ms. Bovang need not prove, however, that Mr. Way took such actions based solely on her reaction to his unwelcome sexual advances. Ms. Bovang can prove the second element of a quid pro quo sexual harassment claim under the state and city human rights laws by showing that Mr. Way was motivated in part by her reaction to his unwelcome sexual advances, even if he also had other lawful motives for his actions. If you find that Ms. Bovang has proved both of these elements by a preponderance of the evidence, you will find in favor of Ms. Bovang on her New York State and city human rights law quid pro quo sexual harassment claims against Mr. Way. All right, we will stop there and try some literary practice. Ready? Here we go. Washington, D.C., the District of Columbia, has never been short on attractions with iconic monuments and superb museums vying for visitors' attention, and when the cherry blossoms return, this city of navy suits comes alive in brilliant colors. Thanks to the past decade's urban revitalization, the city now caters to all stripes of travelers, from deep-pocketed to penny-wise savers. Regardless of which way you lean politically, you will find plenty that will make you fall in love with the nation's capital. Explore the natural core of the nation's capital with a 1-hour guided horseback ride from the Rock Creek Park Horse Center. For those more drawn to the water, a dinner cruise aboard Odyssey affords riverside views of prominent monuments from every table. Admission to the far-reaching and diverse collections of the Smithsonian Museums is free. Also, don't miss the National Gallery of Art, whose 140,000 works follow the development of Western art from the Middle Ages to the present. Use Capital Bike Share, $8 per day, to navigate the 2-mile stretch of the National Mall, a smorgasbord of memorials and cultural institutions. The reigning queen of DC's culinary scene is Rose's Luxury, where such small plates as confit goat will barbecue Sea Island red peas, $14, and grilled quail with apples, $16, keep diners such as the First Lady and her husband coming back. Chef Jose Andres Minibar is an experimental food theater in which diners are treated to dozens of minuscule creations that pack in surprises. Think a rubber ducky made of dried apple meringue and foie gras ice cream. Prefix is $175 per person. Ben's Chili Bowl has served hungry customers as diverse as the city's population, from world leaders to celebrities, business types to tipsy club goers. Grab a famous chili dog, $4.40, which has been feeding Washingtonians since the smokehouse opened in 1958. The bedside touchscreen control panel may be high-tech, but the attentive personal assistants who can plan every detail of your trip are decidedly old school. At Capella, Washington, D.C., Georgetown, the 49-room and 12-suite Canalside Sanctuary boasts a rooftop infinity pool with a bird's-eye view over Georgetown's stately Federalist row houses. Rates start at $545 on a residential street. Near the nightlife hub of the Adams Morgan neighborhood, the 3 decades old and counting bed and breakfast Adams Inn offers accommodations from spare singles to a garden carriage house. The 27 rooms also include pet-friendly options. Rates start at $99. All right, we'll get back to some jury charge practice. Ready? Here we go. Ms. Bovang also asserts New York State and city human rights law quid pro quo sexual harassment claims against New York Global Group and FNL Media. In order for you to find either New York Global Group or FNL Media liable under the New York State or city human rights laws, you must find that New York Global Group of FNL Media was the employer of Ms. Bovang. In assessing Ms. Bovang's claims against New York Global Group, you must consider whether 1. Ms. Bovang was an employee of New York Global Group, and 2. Mr. Way, while acting in the course of his employment with New York Global Group, unlawfully engaged in quid pro quo sexual harassment against Ms. Bovang. If you find that Ms. Bovang was employed by New York Global Group and that Mr. Way, while acting in the course of his employment with New York Global Group, unlawfully engaged in quid pro quo sexual harassment against Ms. Bovang, you will find New York Global Group liable for quid pro quo sexual harassment under the New York State and New York City human rights laws. Similarly, in assessing Ms. Bovang's claims against FNL Media, you must consider whether 1. Ms. Bovang was an employee of FNL Media, and 2. Mr. Way, while acting in the course of his employment with FNL Media, unlawfully engaged in quid pro quo sexual harassment against Ms. Bovang. If you find that Ms. Bovang was employed by FNL Media and that Mr. Way, while acting in the course of his employment with FNL Media, unlawfully engaged in quid pro quo sexual harassment against Ms. Bovang, you will find FNL Media liable for quid pro quo sexual harassment under the New York State and New York City human rights law. If you find that either New York Global Group or FNL Media, but not both, is liable for quid pro quo sexual harassment, you must go on to consider whether New York Global Group and FNL Media constitute a single employer under the law. If the two companies constitute a single employer, one company's liability on Ms. Bovang's quid pro quo sexual harassment claim will be attributed to the other company. To determine whether New York Global Group and FNL Media constitute a single employer, you must consider whether the two companies had 1. Interrelated operations, 2. Centralized control of labor relations, 3. Common management, and 4. Common ownership or financial control. The most important prong of the test is whether New York Global Group and FNL Media shared centralized control over labor relations. The critical inquiry with respect to this prong is whether the two companies shared centralized control over tasks such as selecting, hiring, supervising, and terminating Ms. Bovang and other similarly situated employees. If you find that Ms. Bovang has established by a preponderance of the evidence that New York Global Group and F&L Media constitute a single employer under this test, F&L Media is liable for any quid pro quo sexual harassment attributable to New York Global Group, and New York Global Group is liable for any quid pro quo sexual harassment attributable to F&L Media. Ms. Bovang has also brought a retaliation claim under the New York State human rights law against Mr. Way, New York Global Group, and F&L Media. The New York State human rights law prohibits employers from retaliating against an employee for the employee's opposition to unlawful discrimination, including sexual harassment, or an employee's opposition to unlawful retaliation. In order to prove her retaliation claim under the state's human rights law, Ms. Bovang must prove each of the following four elements by a preponderance of the evidence. One, that she engaged in a protected activity such as making a complaint about unlawful sexual harassment or unlawful retaliation to her employer. Two, that the protected activity Ms. Bovang engaged in was known to the defendant you are considering. Three, that she suffered a material adverse action. And four, that the defendant you are considering took the material adverse action because of Ms. Bovang's protected activity. The first element of a retaliation claim under the New York State human rights law is that the activity plaintiff engaged in that resulted in retaliation against her was an activity protected by law. An employee has a right to report and protest workplace sexual harassment or retaliation where such harassment or retaliation has actually occurred, or where the employee reasonably believes in good faith that sexual harassment or retaliation occurred. Protected activity includes an employee's conduct in opposing unlawful sexual harassment or unlawful retaliation by one, complaining about sexual harassment or retaliation to the employer, or two, by filing a complaint, testifying, or assisting in any proceeding brought under the state human rights law. This lawsuit is a proceeding brought under the state human rights law to prove that she engaged in protected activity. Ms. Bovang need not establish that she was correct in her complaints or that there was indeed sexual harassment. She need only show that she had a good faith, reasonable belief that she challenged actions by her employer violated the law. Ms. Bovang contends that she engaged in protected activity when one, her lawyer sent a letter to Mr. Way on April 29, 2014, threatening litigation against Mr. Way. Two, her lawyer transmitted a draft complaint to Mr. Way on May 7, 2014, and three, she filed the complaint that initiated this lawsuit on July 21, 2014. It is for you to decide whether any of these actions constitute protected activity as I have defined that term. Right, now for some literary practice. This is called Barbecue in the Valley. Ready? Here we go. Some people swear that the only place to get authentic barbecue is in Texas, where the atmospheric heat and tantalizing smell of a meat smoker make for culinary divinity. However, California foodies who call the San Fernando Valley home can argue that both the cuisine and our weather are a clam tootin' good substitute for the Lone Star State. Barrel and ashes. If you prefer your barbecue in an upscale atmosphere, this modern Studio City hotspot is for you. The tender pork spare ribs easily fall off the bone. The Frito pie combines the beloved corn chips with chili and is served per tradition within the original snack size Frito bag itself. Don't miss the hoe cake, cornbread that arrives sizzling in a hot skillet and smothered with sweet maple butter. Dr. Hoagley Wogley's Tyler, Texas barbecue. Although the name of this Van Nuys barbecue mainstay may be funny, the food is seriously good. Try the succulent pulled pork sandwich, which is topped with enough cool coleslaw to provide a crunch with each bite. Finish the meal with a slice of warm house-made sweet potato pie topped with a scoop of ice cream. Swingin' Door, Texas barbecue. Sharing a parking lot with a gas station makes this North Hollywood joint easy to miss. Look for the industrial smoker in the back, cranking hunger-inducing aromas into the air. For a combo plate, the smoky Angus brisket and tri-tip sirloin steak are wonderful companions. The mac and cheese side dish is as deliciously thick and gooey as one can hope for. Every Saturday, Burbank's Handy Market fires up its parking lot barbecue, and by mid-afternoon, the line for fresh off the grill ribs, sausage, and chicken winds down the block, wrapped tightly in foil to preserve the heat for those on the go. All right. That will conclude our literary and jury charge practice.